I mean, Andrew Weissmann has joined us. They also, at every fork in the road, they take the, FU public path. I mean, they could disclose the gifts before ProPublica gets a document proving that gifts were taken and not disclosed. They could recuse from cases where their spouses are cheering on the people who have been convicted of many, many crimes by the Department of Justice. Ginny Thomas and Mrs. Alito are on the side where the Department of Justice has sent hundreds of people to jail. That is the side they're on, the criminals. It also happens to be Donald Trump's side, but it is the largest prosecution in the history of the Department of Justice, and Mrs. Alito and Mrs. Thomas are on that side. It is so twisted. I want to read you Andrew Weissmann. Politico's reporting on the political fallout of Trump's conviction in New York. Quote, the least trusted group of actors did not turn out to be the usual suspects, prosecutors or defense attorneys, but the Supreme Court justices. 39% of all respondents reported having a great deal or a fair amount of trust in the justices, a figure that roughly tracks the court's historically low approval ratings under the conservative supermajority. Something isn't working, and I wonder what you think that means we should gird for in this final flurry of decisions, especially immunity.
Well, I'm going to add fuel to the fire because I want people to understand a couple options that the Supreme Court could have taken in addition to sort of the obvious ones, which was either to not hear the case or to hear the case 6 months ago and decide it quickly, which Mark and Dahlia have spoken about. But here's another thing that is, which I have seen courts do in my own experience, which is that one of the reasons that there is a problem is because there is a stay right now of a criminal case. Normally, when courts have that, they put the criminal case sort of ahead of everything else because they know that the public's right to a speedy trial, the defendant being under a criminal indictment, all of that is a reason to act with alacrity. And so they could have heard this case much, much quicker, but they also could have decided that the stay should be lifted at least for the pretrial proceedings. In other words, that is one of the big problems here is that Judge Chutkan, the trial judge, cannot do anything on the case, can't do any of the pretrial work that was scheduled here because that stay is in place. But there was no reason that they didn't address that at the oral argument and focus on whether it was appropriate, given that there's just no way that they're going to say that there are 5 justices who say that a president is immune from this particular criminal case. If they're going to say that, I mean, you know what? We are so gone as a country if they go down that road that I really can't contemplate it because there really is no check then on executive power. And so they really could have lifted that stay. And the other is, to the extent that they're saying, you know what, we're going to do things in the normal course and we're going to decide, you know, the oldest cases first and the most recent cases last. And this case just came up, you know, late in the day. That is not how courts operate when both sides have an interest in speed, and the court should have an interest in speed because of this pending criminal case. And both sides actually have the only legitimate interest was for speed here. The Trump, because he's saying I shouldn't be charged at all because I'm immune, so he'd want that decided quickly. And Jack Smith, because he's saying there's a public right to have a trial quickly. And so you really end up, as Mark has said, with the Supreme Court disgracing itself in terms of adherence to the rule of law. It is might makes right in the very last place in our democracy where that should be the rule.
Let me show you. I mean, I think we're sort of left to rely on Dahlia, to rely on the utterances of some of the liberal justices, things that they say at other events. Let me just play Justice Ketanji Brown Jackson's question during oral arguments.
What I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world with the greatest amount of authority could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
Andrew Weissmann, if Trump were capable of writing a mission statement for his 2024 campaign, that would be it, right? I mean, this is what he's telling his supporters he wants. I am your retribution. Retribution for what? To be pardoned and to pardon myself, to be there to exonerate myself from the consequences of the crimes I committed. I mean, that is what it's all about. And I feel like when a justice says something is the opposite, we should hear them, because I feel like that is as clear as anything that was uttered during oral arguments, Andrew.
Absolutely, 1,000%. And it tells you how far we have come when you look back to the decisions during, for instance, the Nixon era, where there was unanimity with respect to the role of the court, that the court is a separate institution and is vital to checks and balances. And what you're seeing on the part of the court and on the part of the legislative branch in Congress is capitulation. This is the razor's edge of autocracy, and it is almost unbelievable that Ketanji Brown Jackson had to say that, and that it wasn't a given, given the court's precedent, as Mark pointed out, and that we are at this place. And just to be clear where we are, it does not almost matter if the court writes a big flowery decision about how presidents are not above the law. That is irrelevant, because what they have held de facto is this president is. And everything that happened on January 6th is being whitewashed by the fact that they have sat on this case.